Good morning, Advocate Phahlane.
Good morning, Chief Justice.
How are you, ma'am?
I'm doing just fine, thank you. And how are you doing?
Great. You've demonstrated quite some courage moving from being a receptionist to being a croupier to being an advocate. What very briefly drove you to defy the odds?
You know, Chief Justice, when I was growing up, I come from Garankuwa. I was brought up by my grandmother, who had to take care of me and my siblings and 6 of my cousins. And I never got an opportunity of spending time with my mother. She was a domestic worker. I lived in domestic worker. So growing up in a Shabin, it was very difficult. So my grandmother struggled. My grandfather was not working at the time. My grandmother was obviously a pensioner. And throughout the years, looking at the struggles that we are coming from my family, it was difficult. So when I finished my matric, unfortunately, there was no money to go to school to further my studies. So I decided that I was going to work, for which I did for a period of 7 years. I started first working at the local middle school in Garankuwa Zone 16. It's called Mapenani. I worked there as a clerk for a period of 1 year. And then thereafter, I moved to Mabopane Medical Center. I worked as a receptionist for a period of 4 years. And then when the carousel, Sun International opens its doors, I felt that maybe it was time for me to move to the Sun International, thinking that maybe there's enough money. So I went there for a year, but the times as to the shifts were not conducive. It was very dangerous because the carousel is at Hammanskraal in the middle of nowhere. So I left after a year. And then in 1994, I wasn't doing anything. I struggled to find work. But at the same time, from the money that I saved before, and then I've decided, no, I want to go to school because I do not want to be like one of those states where you finish matric, you're not doing anything. You want to go and be something in your life, and then you cannot do it simply because there's no money. So in 1995, I decided I want to go back to school. I registered at Vista Mamelodi campus. I registered for a BProc degree. And then during my last year, on my third year, unfortunately, one of my cousins who had just finished matric didn't even have the money. We grew up in the same house. So with the little money that I saved from all the piece jobs that I was doing, I had to pay for his fees at Vista as well. He went to Vista Mamelodi as well doing BCom. And then the following year, on his second year, there was no money. So I applied for TEFSA, which is now known as NFSAS. So I applied for TEFSA, which I paid when I started working. And then on my last year of my BProc, which was in 2000, the same year I registered for my LLB, which I completed in the year 2000. And then the very same year, that is when I was admitted.
Wasn't it in 2002? Because it says here that BProc 2000, LLB 2002.
That is correct. That is correct, CJ. That's exactly what I'm saying. I obtained my BProc in 2000, and then I registered immediately to do my LLB. And then when I finished in the year 2000, when I graduated in 2002, that's when I was admitted in the same year of 2002. And then, yes, I joined the bar in 2003.
So you've been practicing for about 17 years or so?
Yes, that is correct, 18 years.
Yes, and you've acted as a judge.
That is correct.
Thank you. Colleagues, let me have the names of those of us who would want to put the questions to Advocate Phahlane.
Magwanisha. Lamola. Mimang. Matonsala.
Tepe.
Singh.
JP?
Thank you, Chief Justice. Hello, Portia.
Good morning, JP.
Forgive me for using your first name. That's how we address each other,
Yes,
isn't
it's
it?
okay. Thank
Sorry.
you, JP.
I have given the JSC a spreadsheet of your work allocations just for the JSC to know what you've done since you started acting. That's the purpose. It provides an objective basis of what you have done to enable the JSC to decide whether you've done enough
Yes,
and whether you are able to take up a permanent appointment.
yes,
And that spreadsheet which you have suggests you've done 76 weeks acting.
that is correct, JP.
And most of those weeks have been in the criminal trial courts.
That is also correct.
That's your special area of operation, am I correct?
That is correct, JP. It is a special area.
But other than being special, and I think I don't want you to be coy, these factors must be told to this commission. The source of briefs that people in your position get mostly come from Legal Aid South Africa, and they are for criminal trial work. Am I correct?
That is correct, JP.
And that's why you've done more in that field.
Indeed so, that is correct.
That out of the way, despite the fact that you've specialized in the criminal trial court, I see you did 4 agent court weeks.
Yes,
You sat in 8 full court appeals, and you did 8 weeks of unopposed motions, in addition to other work areas. I mean, you had 5 weeks of opposed motions. Did you have any problems or challenges dealing with these areas out of your comfort zone?
I would say the agent court is a bit intimidating. When I did that for the first time, I didn't know what to expect. But having prepared, I gelled in with ease.
Yes.
And with the unopposed is challenging because you have to think on your toes. You have to be knowing exactly what to look for in your papers. You have to read your documents and be prepared.
Yes.
Because anything is possible when you're conducting that type of a court. So
Right.
yes, I find it very, very challenging with regards to, I gel easy with regards to the criminals and then the opposed, though it's a lot of work. It's a lot of, it takes hard work to prepare. It takes, dedication for you to know exactly what you're looking for in the papers. It takes a lot of preparation.
Yes.
If you need to be able to maneuver.
Yeah, you started your acting stints in 2017, and over the years, you've continuously availed yourself now and then.
That's
when
right.
you were called. But would you tell the commission you are now comfortable, especially in those areas outside your comfort zone, that you can take up a permanent appointment?
Absolutely true. I'm ready. Well, as time goes on, this is my 9th session being acting. As time goes on, when you started, it's a bit difficult, but as time goes on, you get to understand and know what is it that you are faced with, and then it becomes very easy, though with challenges here and there. But it takes thorough preparation. Sometimes you have to go and consult your senior judges where you are not sure of what is it that you are doing, and you take it from there. But mostly it takes a lot of work. You have to be prepared. You have to be, you have to multitask. You have to be diligent in everything that you're doing. You have to be disciplined. You have to, not that I have to use the word knowing everything, but you have to be like, it's a learning curve every single day.
Yes.
Until you feel comfortable that now I know what I'm doing. I know when this situation occurs, I know how to handle this. Like an agent court, I know what to look for. As long as you know the principles, the rules relating to agency, and you have read your papers and you have prepared, it becomes very easy. But it comes with challenges here and there.
Thank you.
Yes.
Thank you very much, Chief Justice. The MEC will take up his other issues. Thank you. Thank you, CJ.
Thank you, Judge. Thank you, Judge President. MEC?
Thank you so much, Chief Justice. Good morning, Advocate.
Good morning.
I'm trying to get your understanding on reserves judgments that goes beyond the norm, being the 3 months. What's your attitude towards that? And if you can take the tip or commissioners here about your own judgments, if we have others that are outstanding. Thanks.
Can you please repeat that? I did not hear that properly from the beginning.
I'm saying, what's your attitude towards the reserved judgments by other judges where you find that judgments are not delivered within the prescribed period of 3 months? Thanks.
When I started taking up the acting position, I was guided by my senior judges that you have to be on your toes. You have the rule where you have to deliver judgment within a period of 3 months. And when you take up this position, you have to be ready. You have to be able to manage time, which it works in my favor. I'm able to manage time and the workload that comes along with it. So my view is that if you have a responsibility of delivering judgments within a period of 3 months, you have to do exactly that. Be able to manage your time efficiently, be able to manage the workload that you have, and make a schedule for yourself so that it can be easy with regards to making a balance between all the types of work that you have in order for you to deliver judgments in time.
Do you have judgments that are outstanding from your side?
I have a judgment. There was an appeal that I did about 2 weeks ago. It's an appeal from a criminal trial, and that is the only one. I do not have any reserve judgments.
Thank you so much, Chief Justice. Thanks, Advocate.
Thank you, Honorable MEC. Commissioner Matolo Dlepu.
Thank you, CJ, and good morning, Ms. Phahlane.
Good morning, Commissioner.
Okay, we always hear that the bar councils are doing so much to empower women advocates, mentor them. I see you are from the Church Square Bar.
That is correct.
And from the papers, thanks to the Legal Aid South Africa, they are the only people who are briefing you. Do they really do the training or do they mentor women advocates? Have you ever experienced them mentoring women advocates and doing all that they're supposed to be doing when they come here and tell us that?
In the beginning, not at the moment. In the beginning, when I joined the bar, there was nothing. We struggled. We did not have any mentoring. Personally, I did not have any mentoring. What I did is that I immediately after I was admitted, I joined the Pretoria Bar. I did my pupillage there. But unfortunately, because of finances, I had to jump and go to, because I couldn't. I have been responsible for my family to take care of myself and my siblings and the whole family, including other of my relatives. So it was difficult for me being faced with the fact that I have to pay the bar fees and I couldn't. So I had to make a decision, a difficult decision at that matter, that I have to go and join a sidebar, which is the Church Square Bar. So when I got there, it was difficult for us to get work. It was difficult to be mentored. I was on my own, and it was also difficult because when you are, especially the woman, as a female practitioner, you are not treated the same. You do not get the same kind of work that other people are getting. You are sort of, if I may borrow the word, left at the back seat to be fending for yourself. So that is why most of my briefs were coming from the legal aid. And it was also difficult because when you are there thinking that you are in this field, in this profession, which is male dominated, and you want to prove yourself, and therefore you all of a sudden have to be faced with the realities of, no, this is not, a rose of bed, but the reality is there's no work. There's nobody to mentor you. There's nobody to be doing anything. I was in the Bar Council, I think it's around between 2003 and 2005, where I also had to be a party to with those people who were trying to engage the the state attorney to be getting briefs so that everybody, especially with regards to women, because with men, they can just toggle between here and there looking for employment. But to no avail. Up to this date, I've been practicing for 18 years. I've never received a single brief from the state attorney. So as a woman, it becomes difficult that if you are lucky and you get a brief, it will be that brief where you have to go and postpone or settle the matter, but you are not, you are not treated as an equal, if you will, that you have to just prove yourself that you have the capacity and the ability to be able to do your job in court. So the answer is no. I found it very difficult without having anybody to mentor me, but I had to just find my way through on my own.
Okay, thank you, Secretary. I think Commissioner Skok wants to make a follow-up. Thank you.
CJ, if I may make a follow-up.
Commissioner Matolo Dlepu, are you done or are you suspending your further questioning because of the follow-up?
I think I'm done because I see Commissioner needs to do a follow-up.
Thank you so much. Commissioner Sigogo, please go ahead, sir.
Thank you. My follow-up is on the issue that you said it was very difficult, or it is very difficult to get briefs from the state attorney.
Correct.
The minister is here. He shared with us statistics on the briefing patterns. But you said the bar way in which you are is not part and parcel of the GCB.
That is correct.
So there is this notion that we see that mainly the state attorney briefs advocates who are affiliated to the GCB.
That is correct.
And taking into account the changes which were brought by the Legal Practice Act,
yes,
that all legal practitioners must affiliate or subscribe to the LPC.
Yes.
Do you find it justified that preference will be given only to those who are affiliated to the GCB when briefs are being given to advocates?
One must appreciate what the minister is trying to do, that there should be equal opportunities for everyone, especially with the introduction of the LPC, that all the members, obviously, like the Standard Bank Chambers where I come from, the Standard Bank Association of Advocates, they are also affiliated, they are members, obviously, with all practitioners to the LPC. Now, having said that, if this being the position, obviously everybody will be able to get the briefs. And as I said earlier on, that it was difficult when you were not a member of what used to be called the traditional bar, for example, like the Johannesburg bar or the Pretoria bar, it became difficult. But now with recognition of all the others, then it's going to be working for everybody to be able to get that, for the state attorney to be briefing other people.
Last question: are other colleagues in your bar,
yes,
where you are receiving work from the state attorney as we speak?
In terms of percentage, I would be saying 1 out of 10. It's not everybody. They are still struggling. They're still having meetings here and there to be engaged in the state attorney, to be receiving briefs, and it's still difficult. We have, I think it's about 5 months ago, we received a letter from the state attorney where our bar was informed that we will be recognized, we will be getting briefs from the state attorney. But to my knowledge, up until now, no, nobody has ever. I only had 1 or 2 people who have said, yes, we have received, but the majority of them, they are still struggling to get briefs from the state attorney.
Thank you, CJ. Thank you very much.
Thank you.
Thank you, sir. Honorable Magwanisha.
Thank you, CJ. Good morning, Advocate Phahlane.
Good morning, Commissioner.
Indeed, your life history is very inspirational. But I have 2 questions. One is on page 7, your consent to nomination for judicial appointment. In your letterheads, you say you have BProc and LLB honors. The LLB honors, is it a mistake? Because in South Africa, I know for sure that we don't offer LLB honors.
Yes.
And you graduated from Vista.
Yes, that is correct, yes.
Can you explain that one?
Yes. When I wrote that, it was I'll say it was an error, because yes, I absolutely agree with you. There's only one LLB, but I took it from the olden times when you were doing a BProc and a BUris, and then you have to cross over and do your honors. That is when you are supposed to be doing your LLB. So the notion of this LLB is coming from there. But yes, I appreciate the fact that now there is only one degree, which is LLB, for all the law students to be been doing this degree and to be qualifying later when they want to go and practice. Yes, the LLB is the single one, but I was taking it from the notion of these olden days when I was doing BProc and LLB, to be saying that it was an honors.
Thank you very much, SJ, and thank you, Advocate Phahlane.
Follow-up, Chief Justice.
Yes, Commissioner Barnard, please go ahead, sir.
Thank you, Advocate. I just want to make sure I understand correctly. You viewed it, the honors, basically as a postgraduate degree at the time.
That is correct. I did my BProc, and then immediately thereafter I registered for the LLB, which was by then an honors degree.
Thank you.
Honorable Minister.
May I May I proceed?
Yes.
Yes. Given the fact.
Oh, I thought you had finished, Honorable Magwanisha. I'm sorry. I thought you had finished. Please proceed, sir.
No, thank you. Thank you, CJ. Given the fact that you have represented a lot of clients, poor clients, and without an expectation of being paid, do you think the current system, the adversarial system in South Africa, given the inequalities that we have in our country, is the best system? Don't you think that we should consider moving to the inquisitorial system? Because in an adversarial system, those who have money are in a position to hire the top lawyers, and those that can't afford even to pay lawyers sometimes don't get such a good legal advice. Do you think it is the best system to address our inequalities in our country?
I think currently, yes. There will always be inequalities, but the fact that we have an organization such as the Legal Aid Board, the Legal Aid South Africa, it sort of closes that gap where people will be saying, I do not have money or access to the courts because then I cannot afford. There are, there are steps in which you have to go in there, and then you have to put your case before them to be saying, I don't have money, or I do have money, but it's not enough. And therefore, you will be afforded that opportunity. At the same time, the Legal Aid South Africa is also briefing people from the outside, like myself, who are qualified and then who can do a better job. So it's not like everybody's just closed off from having access to courts or having access to legal assistance. So I think with the facilities that we have, from my opinion, I cannot say that people are being deprived because we have the system intact.
Just one follow-up, CJ, if I may.
Please proceed, sir.
Thank you, CJ. Have you ever given thought to the inquisitorial system as an alternative system?
Can you please repeat the question?
Have you ever given thought to an inquisitorial system as an alternative system to the adversarial system?
Not necessarily, but engaging in the two types of system, there has to be a balance. I cannot say that I'm pro or I'm anti. So it depends on what comes before me, and be able to maneuver through that.
Thank you very much, CJ.
Thank you, Honorable Magwanisha. Honorable Minister.
Yeah, thank you very much, CJ and Ma'am Phahlane. My question relates to, firstly, I want to take where Mr. Gogo or Commissioner Gogo left on the briefing patterns.
Yes.
As you have said that there is some work that is being done, and we have also concluded policy development in that regard.
What do you think should be done to ensure that, in particular, women practitioners who suffer more than any other group should be given some kind of priority and preference?
The reality is, it's true, I agree with you, Minister. The reality is that women are being deprived. It's difficult being a female practitioner as it is, but being a Black female in this profession, which has always been dominated by males, it is quite a challenge. I know there are, there's implementations in terms of making everything equal before, in terms of gender, but it's going at a slow pace. Coming from the background of Black women, I'm representing, in terms of talking about representing the women themselves, you would find that there's no balance. There has never been a balance. And even though there are facilities, but it's going very slow. Women are not being recognized. There are those that, I'll give an example about myself, that coming from the background where I am and having to struggle with the briefs, as the minister has said, and where there's always talks, there's always arrangements, or there's always preparations, or that something is going to be done, or something is being done, that women should be elevated, or women should be seen as equals, so to speak, with regards, as opposed to their male counterparts. It's still not, that we still have a long way to go, in that you'd find even now in 2021, women are still struggling. There are, I know of many who are practitioners who have opted to go and do something else in order for them to augment or supplement what they are supposed to be doing. I unfortunately, I happen to be one of those. Coming from the background that I come from, with my family, and with all the difficulties that I had to endure, and not being able to get briefs, one of the reasons why I had to look for employment at UNISA was that it was not enough. I wasn't getting briefs, I wasn't getting anything, and I had to put food on the table. I had to be struggling like all the other women who have been trying to put a voice up there to say, please recognize us. And that is the reason why I had to go and look for something to supplement when I went to UNISA. But coming back to your question, Minister, there should be more to be done. I want to make a plea that enough should be done. It shouldn't just be a talk about we are trying to uplift women. We are trying to make a balance between men and women. But most importantly is that the reality is Black women are still struggling as opposed to their white counterparts. The profession is still dominated by males. And maybe the stereotype of where we are coming from, even previously, it's just, somebody's just talking about it, but nothing has been done. So I would appreciate if more can be done than just maybe the government or somebody or your office is saying, let us do this, and then don't make a follow-up. There should be, if women can get engaged, because they are the ones who are faced with this problem, if they can be engaged to be saying, go and look, try to close this gap and make sure that all the women are treated equally, or all women who are in this profession are getting what is supposed to be getting to them.
Yeah. My second question is, I see that the SCA at some stage had to return a judgment for you to impose a sentence.
That is correct.
Why didn't you impose a sentence, on an appropriate one, on this matter?
That's a mistake I will forever regret. At the time when that matter came before me, the accused pleaded guilty. The state, it was in terms of murder. the state decided we do not want to accept your plea because not all the elements are there. And they decided, the state decided, no, you want to just push this aside. We are not interested, and then therefore we'll have to just present evidence. And when they were supposed to do that, the evidence that they presented did not at the time, if you will, there was nothing that they brought in, because the person who was brought in to give evidence in that matter was a captain who took the accused to do a pointing out, and then he did not make a statement, he did not do anything. So when he came to court, he told the court that 5 months down the line, after he talked to the accused, he was called by the NPA to write a statement and indicate in that statement that the accused have informed them that he has raped the deceased, he has killed the deceased, he has robbed the deceased, but nothing was on paper. So on that basis, I decided that it was my opinion by then that there was no evidence before court in which I can convict. Unfortunately, when because they were the NPA was dissatisfied, they went to the SCA. The SCA set aside my judgment, which I appreciate, which I accept. And then I realized then that I conflated the two, section 112 and section 113. And I shouldn't have acquitted the accused. I should have convicted, and which is a mistake that I shouldn't have done, shouldn't have happened. And I don't think that I will ever happen again, because after that, I learned from that. I had 9 judgments from the criminal trials, which I had to make sure that the mistake that I did from the beginning will never happen again.
Thank you, CJ. Thank you, Ms. Phahlane.
Thank you,
CJ,
Minister. Yes, JP, please
may
go
I have a
ahead.
follow-up that is related to the last issue?
Please go ahead, JP.
Oh, thank you. Related to that, can you maybe comment on page 9, or is it 11, from the letter of, from the National Prosecution Services? It's on page 9, paragraph 11. Do you have that? Where I think it is Mr. Mpaha,
Yes.
who says, and I need you to comment on that. He says, I notice also that Ms. Phahlane would regularly write her heads of argument whilst we are busy with the trial, and once the trial is concluded, her heads of argument are ready, and it is not necessary to postpone for her to write heads. This is a skill only experienced advocates possess, and the only judge that I'm aware of who also has this skill is Judge Ali of the Western Cape Division of the High Court. What can you perhaps please explain or comment? What is it trying to say? Does it mean that immediately after the trial has been finalized, you immediately go to give your judgment, or do you adjourn to go and consider the evidence before you hand down the judgment?
No, JP, my understanding of this paragraph, Advocate Mpaha was talking about when I was practicing as counsel, because usually I was taught that every day when you listen to a matter, when you go and argue a matter as counsel, you prepare every single day. You prepare you do your summary, just as in when you're on the bench, you do your summaries every day. You prepare your heads as you go so that it can become easy. And that is where he was coming from, that as soon as, because I've worked with him on several matters where he was my prosecutor, and as soon as the judge says the matter is ready, then we are going to be preparing for arguments. By then, I would have been ready. My heads of argument should have been ready, because I prepare on a single day. I prepare every day so that I should keep up with everything that I'm doing. I do research on everyday basis, so that at the end of the day, when they say, now we are ready to proceed, now we are ready to argue, and therefore I would, at that very moment, everything would be ready for the court instead of delaying the court. Thank you.
You are muted, JP. You are muted.
Sorry, thank you. I just wanted clarity on that issue.
Thank you, Chair.
Thank you. Honorable Moimam.
Chief Justice, good morning, Judge Phahlane.
Good morning, Commissioner.
My question relates to the JSC questionnaire that you completed on page 20. Can you just take us into confidence into the statement that you make at I think it's the last three sentence of that page on the matter between state versus Kasongo. Kasongo, because you indicate that it is one of the judgment that you consider as a contribution to jurisprudence, and that it touched on security relations with different countries on an international level. Can you just give a thrust of what does that entail? Thank you.
This matter related to, it was the Congolese nationals who are staying in South Africa. They wanted to overthrow the government. So what they did is they invited some of the retired members of the SANDF, the old regime, the members of the SANDF. They recruited them to come and assist them by training them and giving them weapons so that they can go and overthrow their government at the DRC. But what they did, they were training down here in South Africa. So when they were arrested, we were called in to come and assist them, to represent them, obviously. But being charged with the Act relating to Foreign Military Assistance Act, which prohibits any national or every national to take up arms against another country, to be of assistance to another person who is going to be waging war against a foreign country, which is against the policy of the United Nations as well. It was imperative. So I saw that as something which is engaging the rules relating to foreign military assistance in South Africa and the international law, where globally, any person, any nation, any person from any country, any nationality, you are not supposed to be helping another person to be waging war or to be assisting in terms of overthrowing a particular government, because the human rights are involved, the rules of law are involved. So it cannot be that when we having people in our country trying to use the facilities in our country to wage war against another country, that it should be allowed. And it was an interesting journey that it doesn't only deal with our South African law, but if you're making reference or if you're making a research about the international law and how other countries look at this, people who are overthrowing governments in different countries, how is it related in terms of the comparative studies? You find that no, it is not only confined in South Africa, but internationally it is recognized. And therefore, that is why I said it was interesting for me to be working in that. And then I could see that it has to do with the protection or the security relating to other countries as well.
Thank you, Judge Phahlane. Thank you, Chief Justice.
Thank you.
Thank you, Honorable Moimam. Prof.
Thank you, Chief Justice. Good afternoon, ma'am.
Good afternoon, Commissioner.
Can you just perhaps tell us a little bit more of your general experience with matters constitutional and administrative law-wise? There has been a comment that I read where the GCB says you have potential, but you could do with a little bit more experience in administrative law matters and constitutional law matters. Would you mind to comment on that, please?
Absolutely. I did a matter, I think it's a matter of continental powers. It related to the applicant wanted to have a tender to supply electricity. And that matter, when it came, he you know, the applicant was saying that the policies or the rules that have been applied are not giving him the opportunity because they are depriving him. And is through in some sort of the constitutional aspect of it to be saying that in terms of the constitution, I have the right to free trade. I have the right to be able to be considered like any other person, to be able to trade. And because I'm deprived of that, therefore I have to be getting this. But however, because it was an application in terms of PAJA as well as to whether, because there was a review before, in terms of whether the decision that was taken before for him to be deprived of such can be said to be a constitutional issue or can be said to be confined or limited to PAJA itself. So that is where the issues were coming from. But yes, I agree with the GCP. I do need to be exposed or to have experience in terms of constitutional law and administrative law because I have limited knowledge of it.
Okay, so you concede that you do have limited knowledge on that.
Yes, absolutely. I do concede. I haven't been exposed in the matters that I have done. I haven't been exposed too much in relation to constitutional matters. But obviously, one has to deal with constitutional issues every day in all the cases. It depends on the type of work that you're doing. In criminal cases, obviously, we deal with constitutional issues every day when it comes to the rights of the accused, when it comes to other rights as well. In terms of when you're talking about in relation to this as well, there's another matter which dealt with, it had to do with the issues of the constitution. It was a matter that I did with AfriForum. It also dealt with the constitutional issues relating to, it was a matter where the administrator, the decision of the administrator to cut off the budget or to approve the budget was an issue before me. So at that time, I was just faced for the first time with a matter like that, to not being exposed to constitutional matters. So it had to do with that, and then I had to deal with it at that moment. But yes, I need more exposure.
Okay, ma'am, but how do you foresee, will you equip yourself in those areas to be able to deal with those matters were they to come before you if you were to be appointed? Or are you going to wait for the cases to arise and then just rely on the legal counsel? What would your approach be?
No, it takes dedication and hard work. You, on a daily basis, like I said earlier, on a daily basis, you are somehow in each and every case that you deal with, you are somehow faced with the issues dealing with constitutional law, but it depends on where the case is coming from. So I cannot wait for a matter when it comes and at that moment I cannot deal with it. I have to be ready, I have to be prepared, I have to do my research every day, I have to be able to know what the law entails. I have to be in a position to know that if I deal with this particular type of issue, how do I handle it? I cannot just sit and wait and say, I'll wait for a particular case. No, I have to be on my toes.
Thank you, ma'am. Thank you, Chief Justice.
Thank you very much, Prof. Advocate Madon Salesi.
Sorry, Chief Justice.
Yes, sir.
Yeah. I'm just trying to make a follow-up from the previous question, if you don't mind, Chief Justice.
Please just a small thing. Please go ahead, sir.
Advocate, on that AfriForum and administrator case, I just wanted to know what was the final decision there on the AfriForum matter.
My decision was that the administrator was given the premier had given him the powers to take over as an administrator, which was the powers his duties were published in the government gazette. So my decision at the time was that the administrator was within his rights, given the powers by the premier to, his powers were not limited in terms of the papers that I had before me, he was given the powers to act as a council, so to speak, as the council of Tshwane Council. And that is where my judgment was coming from, to say that he wasn't acting on his own, but he was given these powers by the premier, who had the powers at the time to instruct him as to what is it that he had to do, and hence the decision that I came with.
Thank you so much, Chief Justice. Thank you.
Thank you. I almost said Premier, I don't know why. Advocate Madonsa, let's see.
Thank you, Chief Justice, and good afternoon or good day, Ms. Phahlane.
Good afternoon, Commissioner.
No, I will not now ask you about the lack of briefs from the state attorney, which is you attribute to you not being member of the regular bar, the Supreme Bar. I say so because I've been at the bar, in the regular bar, and I've not received the state attorney work from the kids and state attorney in the past 15 years. So the problems are much bigger than being part of a bar.
Yes.
But we can deal with it some other day. There is a complaint,
yes,
or rather an objection by a certain Ntabiseng Skosana,
yes,
which we have dealt with it. I don't want that complaint or objection to stand in your way. I see that as late as yesterday or day before yesterday, you gave us a response to that objection. In brief, can you just clear that air away by giving an oral presentation? What do you say to that complaint, in essence?
This objection, in my view, it has no merit. I got a sense that maybe where she's coming from, I may be wrong, but I got a sense that where she was coming from, she expected me to be taking sides as a woman. That when you are having a problem with your partner and then you are fighting with a man, or with the father of this child, with this minor child, therefore I had to just be on her side. The fathers also have rights, and that is where I was coming from. But most importantly is the fact that she was given too many opportunities. I normally say to councils, even if it's not councils, but I normally say to people when I speak to them that, you know, I like repeating myself so that you should not say that you did not understand. And that is why when she said that I needed to have the right to legal representation, I needed to go and consult, I gave her that opportunity. I said to her, please inform your council that we are in an urgent court. Please inform council that this is how it's supposed to be done. And I specifically and thoroughly, repeatedly so, explained to her the procedures as to what should happen and what is expected of her to be doing. And she did not do that. You saw from my response when I gave a detailed explanation of what happened. She was given an opportunity by the council for, the instructing attorney for the applicant, over and over, given, send SMSs, send WhatsApp messages, emails were sent to her, phone calls were made to her, and she did not do anything. Unfortunately, you know, there's always somebody who will always get, when you're having parties, somebody has to lose, somebody has to win. But when a party is not happy, there are remedies, there are procedures to follow. And the fact that we went, my registrar went to an extent of just making sure that she is protected, get a lawyer for this person. And then still she did not do anything. But what was important and where I was coming from was the fact that there was an agreement. When I engaged her, when she was there with Advocate Granova, I engaged her. I wanted to understand where she was coming from, because she said, when she came, she said, no, I don't want this man to be taking my child away from me, because right now I'm not working. And then when I asked her, but wasn't there an agreement before? She considered, she said, yes, there was an agreement. This person, this man has been taking care of the child. He would be taking care of the child for the whole week, from Monday to Friday. Over the weekend, I would take the child. But at the time when she was supposed to take back the child, she refused to do that. And I said, but if you have an agreement, what am I supposed to do? You agreed with this man. And that is the reason why this man says, because you do not want to, to fulfill in terms of our agreements, therefore, let me go and get some assistance, legal assistance. But it wasn't about that. It was about whether the best interest of the child will be taken care of. And part of it was because this man, the applicant, was saying, as much as we have problems, as much as I can see that when you are bringing the child to me, I can see that the child is behaving strangely. I'm more than willing, as the father of the child, I want to cater for this child. I'm more than willing that I would go and appoint that, even if you can do that, or anybody can do that, let a social worker be appointed, let somebody intervene to investigate where the child should go and stay.
Yes.
And that is why I went with it.
Thank you for that. So in a nutshell, it's a case of a disgruntled litigant.
That is correct, yes.
Thank you. Chief Justice.
Thank you,
Chief,
sir.
Chief Justice, may I follow up on that and forfeit my right later? Singh, yeah?
Please go ahead, Honorable Singh.
Thank you very much. I know my KwaZulu-Natal Senior Counsel, well, he thinks the same as me, so he asked that question. Thank you, Commissioner Madansala. Good morning, Advocate Phahlane.
Good morning.
Firstly, I want to compliment you for your continued perseverance in your life and the fact that you certainly would have inspired others around you. Coming to this case here of the complaint from Ms.
Phahlane.
Yes, from Ms. Skosana. I would just like to know and just satisfy myself, because when this matter was heard, she had replying affidavits were not submitted on time, which is something that you state. And then you say those affidavits came in 5 minutes before the matter was heard.
That is correct.
I just want to know, do you think you were fair and just in your application of legal principles in, the fact that the matter came 5 minutes before, so there was a replying affidavit, and were any of those facts contained in that affidavit considered when you gave your judgment? Just thank you.
Yes. The case line system that we are using now has the opportunity of giving you, when each and every matter, when it comes through your email. So immediately, automatically, you know that there's a case before you and you have to just connect to the case line system. So yes, I considered the affidavit that was sent. And when the case was presented, I still felt that the applicant had a good case. The part of the objections that are there, as I indicated in my response, were not placed before me. So they became as new evidence to say, if now when the objection is made, a complaint is made about exposing the child, which was not there. So my decision was not only based on the fact that her affidavit was late or it was not considered. Yes, it was considered, as I explained earlier on, that when the matters come, they come through the case system and immediately you have an access to them. So you are able to see what is before you. So you cannot ignore any other paper, irrespective of whether that affidavit was delivered late or not. I have to consider that. And that's exactly what I did.
Thank you, Advocate. And in the light of the new information that she refers to in her letter to you and your letter to us, that information would not have been before you at the time you considered this matter. But has she been advised to take this matter up further? Because it can be quite a serious matter if it is exactly what she is alleging there.
If I understand, is the question that has she been advised? Are you referring to being advised by myself?
Yeah, or anybody else, to say, well, if you've got these further allegations of, and you know what the allegations of living with 3 men, etc., Was she ever, consulted by anybody to say, well, this is an important matter, please take this matter up again further?
No, the last time I saw, I was, I had contact with this matter was when the parties were in court. But as I said, and as is evident, the complaint regarding the child being exposed to 3 men, it never came to my attention, but only at the time when a complaint was made or an objection was made. So I didn't have the opportunity, and I couldn't have had the opportunity, but I want to believe that because she was guided at the time by counsel who is qualified and who is a member of the bar when he was representing the case, I want to believe that she has been advised that this is a serious matter and therefore that you can go forward. But for myself personally to be engaged in that or to be involved in a matter where I have to advise one of the parties to say, you have to go forward and take up the matter, for example, to another level, I couldn't have done that. So I
No, I
only
appreciate-
dealt with the matter only when it became before me.
I appreciate that, Advocate Phahlane, but do you just think outside of this matter that ex post facto, she should not be somehow advised to take the matter further if it's as serious as she alleges? That's all, thank you.
No, absolutely, I agree. If this matter is so serious to an extent that the fact that, the objections or the complaints that are raised now in this objection they are there, they are true, as she says in her objection. Therefore, yes, absolutely, she has to take the matter up. She cannot just leave that. Hence, I said in my response that should I have known at that time, I would have taken a different approach, but I was not at liberty to be exposed to that information. But yes, I regard it as very serious.
Thank you, Advocate Phahlane. Thank you, Chief Justice. I'll forfeit my right for later.
Thank you, sir. Commissioner Tsepe.
Thank you, CJ. Good morning, Ms. Phahlane.
Good morning.
Your tenacity is quite remarkable. I just wanted to let you know, and it's very good. Thank you. Just 2 questions, Ms. Phahlane. In your questionnaire, you talk about your role at the University of South Africa, marking scripts and assignments in the law of evidence, media law, I think, and the criminal law module. What do you think that? I guess my question is, how has that assisted you in dealing with other areas of law that you would not have been exposed to in your practice? And is that relevant for purposes of your role as a judge or acting judge for that matter? Thank you.
It has assisted me a lot, especially with regards to evidence, because no matter which area of law you are dealing with, we are dealing with evidence when I'm in court. So being exposed to being or having the opportunity to mark exams and scripts, they are updated yearly or even maybe within a period of 2 years as to updating the law themselves for students who are registered to do their LLB. So when I'm doing that, it gels in together. It's incorporated in exactly what I'm doing at work when I'm on the bench or even in practice. So all the principles relating to the law of evidence are there. They are not different from any other thing. So what they are being taught at varsity and what I'm doing in my duties as counsel and on the bench as well, acting, it's exactly the same principles. With regards to media law, it has got to do with not only the law students, but there are those who are doing in the media industry who want to become journalists. So the section 16 part of it is also there because they are doing part of the constitution in their modules. So yes, it does help because you don't only find that there's media every day in court. So more often than not, you'll find a journalist, for example, asking for permission to come and do the proceedings live or to do what. So if you're coming from that angle, then you understand why the journalists want to be in court, why you have to say yes to them and give them the opportunity, because a courtroom is a public place. But at the same time, most important is that they are entitled in terms of Section 16 to be present and to be the voice to the nation, to be the voice to the community.
Thank you, Ms. Phahlane. My last question relates to comments from the GCB. I don't know if you have had an opportunity to look at them.
Yes.
In paragraph 6, they talk about the what you say about the matter of the SCA, and they're saying that your description of what the order of the SCA is in respect of your matter is not correct. Do you have a comment on that? And there's another one in relation to paragraph 12, but can I ask you to deal with paragraph 6 and then we'll come to paragraph 12?
With regards to the matter from the SCA, I think what I've noticed is that the person who was making a comment didn't go further than what was before the SCA, because the last paragraph of the order of the SCA was that the matter has to be referred back to the trial court for sentence to be imposed on the accused. So there's where the difference is coming from.
Thank you. And I just think it's important to note that we need you to explain this thing so that when we deliberate, these issues are cleared out. And so an example is your answer is a typical example where there would have been miscommunication or misunderstanding. So thank you. And with regard to how you conduct proceedings as stated in paragraph 12, would you like to comment on that? Do you want me to briefly?
Oh, yes, please.
Essentially, they're saying in the one matter, you changed a draft settlement agreement between the parties without giving them an opportunity to be heard. And in respect of the other matter is you gave an order where the party had not put the facts under oath.
I'll deal first with the issue relating to a draft order. That is not true. And here's my reason. When a draft order is made, it is made in the presence of the parties. It is declared an order of court. So I cannot on my own go and change the fees that have been declared on the order. It's a court order. So it cannot be changed. And I haven't had anybody, if it could have happened, nobody has ever approached me to say, but we gave you this document with such an amount of money and a mistake maybe could have happened. Nobody has ever done that. But as I said, when an order is made, it cannot be changed. And I cannot go on my own to do that. With regards to the second part of your question relating to this matter, if my recollection serves me well, it had to do with this other gentleman who, it came before an unopposed, it was an unopposed matter. You know, dealing with so many matters in a day, in an unopposed court, you're given something like 70, 50, but that's not the point. The point is, when you are a judicial officer, you not only looking at your papers, but you are also looking at, you also have to always present, be mindful of the fact that you are there to assist, open to justice, open the doors to people. When this particular man came to court, the first thing that he did when he opposed the application was that he asked for relief. He did not have a cent. That is why he did not even have legal representation. But I was faced with a situation where I had to deal with the matter immediately. I had an option, yes, of just sending him to go and do an affidavit. But at the same time, I was faced with a situation where I wanted to deal with the matter and expose of the matter instead of just congesting other courts' roles. Yes, I should have sent him to the other court to say, go and do an affidavit, appear before this court. But when you are making a balance between whether are you going to deny access to a litigant who is not represented, or whether you are going to be making a balance as to whether justice can be done, there always has to be a balance, unfortunately. But with regards to the question itself, in answer to your question is that yes, I should have sent that man to do an affidavit, but at the time, I was trying to give him access to courts, more particularly because I was thinking more like what he related in the first instance when he came to court to say, I do not have the money. I did not even have the money to come to court today. And therefore, if I were to send him to another court, it was going to be a hurdle for him. So was I doing justice to him? I believe I did.
Okay, thank you, Chief Justice. Thank you, ma'am.
Thank you.
Thank you, Commissioner Tsepe. Advocate, thank you very much. You are excused, ma'am.
Thank you. Thank you, Chief Justice.